small, so I'm not going to ask for comments, but when we get to the three big areas, then I'm just going to go ask everybody 1 through 10. Hello?
Yeah, just to let you know we're live on YouTube now. So.
Oh, okay. Well, hello, everybody.
I don't think anyone's listening yet.
Great. Oh, no, we have a huge, right? We're live on YouTube. Well, I have my camera here at the office, so let's see what I look like. Last time. Oh, good. So let's see. Can you have the rule changes on the share screen?
Yeah, so you want me to handle the share screen?
Yeah.
Okay. Yeah, I can do that. I made you a co-host, so you should have all the authorities as well if you need them.
Okay. Someone entered the waiting room.
Yeah, it's me on my mobile
Okay.
phone, so I can set up my video. Hello, Commissioner.
Hey. Okay.
I'm starting to admit people as they arrive, so.
I'm gonna move my chair around so I'm not baking in the sun here.
It must be warm down in Las Cruces.
Well, you know, it's high 60s, but when you're in the sun, it definitely is warm. Hey, Christopher.
Hello, Chairman. How are you today?
Doing good. But, you know, I'm almost not chairman anymore. And I hope your boss isn't just rubbing his hands together a chance to fix everything I've done.
Well, I didn't want to interrupt the meeting yesterday, Commissioner, but honestly, I've seen many chairs and you're definitely in the running for the best. You got people to, you really tried to get people to come to yes, if you know what I mean.
Well, I appreciate it. Thank you for saying that.
No, I mean it. I would never just say it. So,
I know that.
yeah, because, okay, now my screen. Do it. Well, I don't know if you can tell, but I am at the Bochum building.
Yeah, I can see. But you're in the dark. You need to,
Well, the reason it looks like I'm in the dark, and maybe if I turn off the light.
well, probably just tighten the shades behind you.
Yeah.
I want to see when you're grimacing and smiling and, you know,
Yeah.
got to do the nonverbal communication thing here.
Right. Well, let's see what this looks like. It doesn't look much better. It's just the way that they have, in fact, it looks worse.
It looks like you're in witness protection.
That's, oh my gosh, you're like the third person who said that. Maybe if I can turn the screen, let's see, like this, and that's probably a little better. It's
Or if you
because,
sit on the other side of your desk, but you might need to be near your computer.
yeah, I'm trying to,
So, you know, Leslie, you look beautiful, well lit, even.
Well, thank you. I actually thought my lighting was not that good today, but the angle of the sun is just pretty bad.
yeah.
Well, your makeup crew's done wonders.
Thank you.
Well, when you work for PNM, they do give each lawyer their own personal makeup person, right? Right?
I wish wardrobe would be nice too, huh?
Yeah.
Right.
Well, so Leslie, is that a reason to work for PNM or a reason not to work for PNM?
Well, let's establish first that is not true. But,
Yeah, I have a feeling I have a feeling most people do that wasn't true. You do get other perks.
But if
but
it were true, then of course, who wouldn't want a wardrobe budget? I don't know, then, because then there's the messages, you need to dress decently, which, after
Exactly.
a year and a half of the pandemic, I don't think many of us are inclined to do.
Mhm.
Yeah, I can only dress okay from the waist up now.
Well, I'm gonna
Go ahead.
stand by the conversation I had with Commissioner Byrd before yesterday's meeting, is that nothing's beautiful unless something's ugly. And that's why Commissioner Byrd and I were put on this earth.
Well, at least you guys have a purpose,
Yeah.
right? I think we have probably everybody that's going to join. Right now I have 133. I hope no one minds if we start the workshop. This is, my name is Judith Amer, and I'm an Associate General Counsel at the Office of General Counsel at the New Mexico Public Regulation Commission. And this is a workshop in case number 20-00158, which on October 27th, the commission ordered that the caption would be changed and that this docket is now entitled in the matter of the commission rulemaking regarding NMPRC Rule 17.9.572 NMAC renewable energy for electric utilities. In addition, that October 27th order scheduled a workshop for today at 1:30 p.m., which that we are having. And it went through the history of this docket, which has been long and complicated. And I could go through it. Basically, it was in the original rulemaking docket, 19-00296, where the commission granted on August 5th, 2020, utility division's staff's motion to bifurcate. And therefore, this docket was open. And originally, this docket was open to inquire into an issue regarding renewable energy riders and line loss adjustments. And the commission asked for comments and did receive them from City of Las Cruces, EPE, Louisiana Energy Services, NMAREA, Occidental Petroleum, PNM, SPS, and staff. All agreed there was not a statutory requirement for public utilities to recover costs of renewable energy procured to comply with the renewable portfolio standard through a rate rider. In addition, the comments were split on whether or not the renewable energy riders provided useful information. Therefore, part of this docket now, it has will address the continued use of renewable energy rate riders. So that was one of the first findings of that October 27th order. In addition, in that order, the commission decided it was not efficient to pursue the inquiries 6 and 9 of one of the orders in this docket at this time. Not that they weren't important, but that we needed to set priorities and reserve those inquiries for future dockets. In particular, that had to do with line loss adjustments and whether costs could be saved by eliminating the RPS writers. There was also an issue that arose in the original rulemaking docket 19296 regarding the phrase capital investment opportunities. That is part of the definition of financial incentive. And would the financial incentive be able to incentivize the closure of Four Corners generating station? Does the 100% zero carbon standard by 2045 include the 2040 renewable portfolio standard of 80% renewables and limits nuclear to 20%? And whether the financial incentive would apply to a non-regulated entity such as Arizona Public Service Company. And a definition of average annual levelized cost for purposes of the reasonable cost threshold. As this docket went on, commenters were split on whether or not the financial incentive could be used to incentivize the closure of Four Corners or another carbon dioxide emitting generating station. In addition, commenters were generally supportive of formulating a formula definition of average annual levelized cost. For this reason, part of this docket will now be formulating that definition of average annual levelized cost. And clarifying whether or not the financial incentive could incentivize the closure of Four Corners or any other carbon dioxide emitting generating station. So that's a brief overview. And at this point, I would like to have Robert put the rule on a share screen so that everybody can look at it. And we can go, get rid of this.
Judy, this is David Black.
Yes,
How are you?
good. How are you?
I'm doing fine, thanks. Staff wanted me to clarify a misunderstanding that appears in the October 27th order in footnote 12 regarding inquiry capital B, lowercase b, regarding the financial incentive regarding can the financial incentive be used to incentivize the closure of Four Corners Generation Station? And there is a misunderstanding in that footnote 12. It says the city of Las Cruces and staff were non-responsive to that inquiry. Staff's July 30th, 2021 response to that ordering paragraph capital B, lowercase b, was perhaps misunderstood. The response simply should have said, no, any incentive must be tied to, tied to the acquisition or production of renewable energy resources as required by the text of the statute. And because the wording of the statute is clear, staff did not see fit to offer any proposed rule language which would simply have parroted the verbatim wording of the statute. So in other words, staff's July 30th response was not non-responsive. There were lines and lines of response addressing that issue, and I just needed to make that clear.
Okay, thank you. Thank you very much. Well, with that, I would like to welcome Commissioner Fishman. He is the only commissioner present. Thank you for attending. And I'd like to welcome everybody else. And at this point, I would go through page 1 of the Exhibit A, which was attached to the order that gave the instructions about this workshop. And as you can see, the commission is proposing to add a definition of average annual levelized cost. And I won't read it because you can read it yourself. This was, I believe, proposed by, someone should correct me if I'm wrong, one of the either P&M or SPS or both.
Judy, this is
yeah.
Robert. Yeah, so this was taken almost verbatim from SPS's comments, and I don't think SPS is represented here on the call.
Okay.
But it also closely resembled language from P&M and NM area as well, I believe, from memory.
Oh, good. Okay, thank you. And I'll just go through the list of participants, see if anybody has anything to comment about this. City of Las Cruces, Anastasia. I don't know if she's present.
I think she's involved in the EPE fuel FPPCAC case right now,
Okay.
presently as we speak.
Okay, from staff, I have Alicia Leyva Tercero and David Black. Would staff like to comment on this definition?
Yeah, I defer to Alicia.
Hi, good afternoon. Alicia Leyva Tercero on behalf of Utility Division staff. Staff is supportive of this language as indicated in staff's responses to inquiries that was filed on July 30th, 2021. Thank you.
Okay, great. P&M, either Brian Buffington or Leslie Padilla.
Leslie Padilla on behalf of P&M. Yeah, I'm not sure if we actually used the mathematical formula, but the formula, what the formula represents is something that P&M also proposed. So we don't have any issue with this language.
Thank you. EPE, we have Renee Gonzalez, Chris Hutchison, and Carrie Olson. Which one of you would like to comment? Carrie. Hi.
Amber, this is Carrie Olson. Unless anyone from EPE has specific comments, I think we are primarily intending to just observe today and then provide any written comments by the deadline if we have any additional comments.
Okay. Anyone else from EPE? Oh, hello. Yes, Curtis.
Yeah, sorry. Yep. I agree with Carrie. That's what we agree.
Okay. Mary Jane Parks. Mary Jane
Yes.
Parks? Hello.
Yes?
Do you have any comments?
No.
Okay. Austin Jensen.
I'm Amer. I'm here on behalf of the New Mexico Large Consumer Group. I have no comments on this piece.
Okay, thank you. And then last, I see the Attorney General Gideon Elliott.
I have no comments. Thank you.
All right.
Hey, this is Kelly Gould with NM area. I'm on too.
Oh, thank you. I didn't have you on my sign up list.
Oh, okay, sorry. Yeah, that's okay. I just wanted to let you know that I was here and we don't have any comments on this specific change.
All right, well, with that, I think we'll go further down the rule. There's some minor changes that I don't think we need to discuss. like in section 10, changing must to shall, 10C, changing is to shall be, in 12B, changing should to shall, 12C, fixing a typo.
Judith?
Yes.
Hi, Leslie Paddy on behalf of PNM. We do have a comment on that change in paragraph C there.
Okay.
We do recognize there appears to have been a typo in the existing rule, in the current version of the rule, but the
Right.
change that you've made, I think, is the opposite of what the statute says. I think we need to insert the word do not, because the language of the
Okay, I think you're right, because I was, yeah, you are right. Because I was looking at the statute just yesterday, and you're right.
Brian Buffington brought that to my attention, so I appreciate his input.
Okay. Thank you. That we will make that change. That's very helpful. Okay. Now I have to find what I was looking at. Okay. So that is do not.
I changed it, Judy.
Okay, thank you. Section 14, A, changed must to shall, changed a typo on occurring. In B, changed is to the word shall. In 15, so this is probably one of the big ones. I hope people will comment and not just say that they're going to reserve comments. But anyway, I was added, and it states that a public utility that utilizes a rate rider to recover the reasonable cost of complying with this rule shall, beginning with its annual Renewable Energy Act plan filing due for plan year 2023, pursuant to the rule, include a transition plan demonstrating how the public utility shall transition from utilizing a rate rider to recover the reasonable cost of complying with this rule to recovering costs through a general rate case filing and or its fuel and purchase power cost adjustment clause. The public utility shall not utilize a rate rider to recover the reasonable cost of complying with this rule by no later than plan year 2024. So again, I'll go through the list. Anastasia is not here. Staff first would be either Alicia or David.
This is Alicia Leyva-Tercero. So staff believes that there are benefits associated with the use of rate riders for recovery of the reasonable costs of complying with the RPS, such as transparency, timely cost recovery, reduced carrying charges, prevention of the accumulation of costs that may result from costs deferred for future recovery and base rates. And this is all set forth in staff's responses to inquiries that was filed in this docket on March 2nd, 2021. However, staff recognizes that there is no statutory requirement for public utilities to recover the costs associated with RPS compliance through rate riders. And so therefore, staff is not opposed to a transition from utilizing rate riders to recover these costs to recovering through base rates and or the FPPCAC. Thank you.
PNM, either Brian Buffington or Leslie Padilla. Brian or Leslie, I think Leslie, you need to unmute yourself.
Yeah, there I am. I'm unmuted. In the March 2nd, 2021 list of questions, we did, as Ms. Amer noted, agreed that there's no statutory requirement that utilities recover the cost through riders, but we also noted importantly, the Renewable Energy Act also doesn't allow the commission to eliminate a rider as a permissible means of cost recovery. So we've made comments, I think at least 2 times so far in the different rulemaking proceedings, and our position hasn't changed because the law underlying the use of rate riders to recover costs has not changed. And the law is this: the Renewable Act itself states that a public utility that procures or generates renewable energy shall recover through the rate making process the reasonable costs of complying with the RPS. And then there are 2 Supreme Court cases, one dating from 2003 and one from 2007, that when read together really do establish that a rider is an appropriate rate making process. The commission has relied on those 2 Supreme Court cases to determine that recovery of RPS compliance costs through a rider was lawful. So PNM believes that the legislative history, the Supreme Court opinions, and the commission's own precedent make clear that the commission can't limit the methods of cost recovery to exclude a rider. And then equally as important as the law, PNM believes, as staff just noted, that rate riders have benefits. We believe they have benefits to customers. We've tried to explain those benefits in some of our earlier comments. Riders, for example, mitigate the accrual of carrying charges that would accumulate if only rate case recovery is allowed. The annual true up of asset depreciations reduces the annual revenue requirements, which reduces customer bills. So if costs were in base rates, those costs would remain constant until the next rate case. And since we've made those comments previously, and we now have a proposed rule that does eliminate the rider, what we'll plan to do is we're going to quantify those benefits in our written comments, just to try to explain better our position that rider recovery is actually good for customers. And then I wanted to also suggest perhaps a different approach might, I know the commission is concerned that riders might not be necessary because renewables are becoming a larger and larger part of our generation. But perhaps the better approach would be to identify more precisely exactly what RPS compliance costs are. Not all renewable energy that utilities procure these days is procured solely to comply with the RPS. So in PNM's case, when we propose renewables that are needed as system resources, when we've done the resource modeling, our planning, and we show that the renewables are the least cost resources and we're going to add those, then those costs are not recovered through the rider because we don't consider those necessary to comply with the RPS. They will contribute to our compliance with the RPS, but we're doing them because it's a system need. So those won't be recovered through the rider. So that's PNM's position on. So we would oppose this language, this proposed language in I.
Well, thank you, Leslie. Yes, I have read your previous comments, and this is a discussion draft, and it's not a no-first rule yet. So we'll take that into consideration. Next,
Madam Chair?
Yes.
Madam
Commissioner
Chair
Fishman.
Judy.
Yes.
In terms of asking questions, I'm not quite sure how you want to procedurally do that. Do you want to get all the comments first or?
Well, okay. Either one. If at this point, since it sounds like you'd like to speak with Ms. Padilla, it might make most sense for you to comment now.
So just quickly, a couple of things for clarification. My sense so far is that just about all of certainly PNM's renewables are through purchase power agreements, and as such, do not accrue carrying costs. Is that correct?
That would be the case for new, I think for the most part, for new renewables that we're adding. Certainly the renewables that we're proposing in our current Palo Verde replacement resource case are all PPAs or energy storage agreements. So yes, those would not be recovered through rate cases, but through the fuel clause is my understanding. We still have existing rider, existing costs that we're recovering through the rider though. And my read of this new language in paragraph I would require us to, well, it says there explicitly, we have to show how we would transition from using the rate rider. And presumably that means taking all costs that we currently are recovering through the rider and figure out how to recover them through, that would be through a rate case, through or the fuel clause or the fuel clause. But it's also not to say that all of our procurements in the future would be purchase power agreements too. I mean, we still have the ability to build our own resources if that's the most advantageous for our customers.
Okay. Also, you made a distinction between needed. First I'll make one other observation. The only recent case that we've seen where a utility is owning renewable assets, they chose not to put them under the Renewable Energy Act. And as an owned item, felt that it was fine to get cost recovery through traditional rate making purposes. And in terms of owning an asset, do you see that? I would see where there's an ownership. It would very likely be the case ongoing that if they felt it was a financially competitive resource, a utility would prefer to own it and likely would not put it under the Renewable Energy Act. What are your thoughts on that?
Yes, Commissioner Fishman, I believe that's consistent with kind of the approach PNM has kind of laid out in both comments and in a previous, I can't remember which procurement case it was, but if we have, done the analysis to establish that a needed resource is a renewable resource, but it's needed to meet system needs, then that would not be, we would not seek recovery of that. However, it's procured through the rider, through a rate rider.
Okay. And in terms of meeting system needs, how do you, or is she frozen?
Commissioner Fishman, you cut out for a second.
Okay, I'll try again. Sorry. So how do you define that term, system need?
Well, Commissioner Fishman, I actually I'd reviewed some of our earlier comments before this session today, and I would note, I kind of, unfortunately, I'll just read this. I'll try not to, but here's how we proposed, or we could propose. One reasonable way to assess whether a resource should be considered in an RPS filing or a traditional CCN or PPA filing would be to perform a portfolio analysis with and without the RPS requirement. When performing a portfolio analysis, P&M can enforce a binding constraint for the portfolio to meet the RPS requirement that can cause the model to select resources that may not have otherwise included in the portfolio. After determining a lowest cost portfolio, P&M could reevaluate the portfolio without the RPS requirement to determine if any near-term procurement decisions would change. So that would be a way of, establishing whether, a resource is needed to meet RPS or just would need it as a system resource.
So I guess I hear that and I go, gee, it's kind of arbitrary what you pick was necessary for system need. I suppose you're going to be sorting, you're planning to sort that by cost?
This goes a little beyond my very limited technical capacity, but we can certainly flesh this out in our written comments that we're planning to file later this month.
Okay. So would you consider, when we use the word system need, why wouldn't something that's required to meet the RPS be considered a system need? Just like something you need for reliability, to meet reliability standards is a system need. Isn't it pretty much established in statute that, hey, this is a requirement of the system for us to consider it meeting the performance requirements that the public has?
I think things have clearly changed a lot since the RPS was first put in place, and utilities were having to add a lot of renewables and that's the whole purpose of the reasonable cost threshold, why it was needed initially, because a lot of initial procurements by utilities were making costs more expensive for customers. That's become less the case, but there still may be instances when we are required to procure renewables to meet to meet the requirements of the law that may go beyond what we would have acquired to meet system needs without the statutory requirement. But the point you're making too, though, is that because the statute requires it, that's kind of been a traditional basis for allowing rider recovery also. When something is required by the law, whether it's going to be grid mod expenses, transportation electrification expenses, when there's a kind of legislative imperative to do something, rider recovery has often been allowed.
Okay. And in your comments, if you can flesh that out some, certainly it'd be welcome. Not required, but certainly welcome.
Sure.
And Commissioner Fishman, this is Brian Buffington at P&M. Just to clarify one of your earlier questions.
Sure.
We have about 115 megawatts of company-owned renewable resources in our rider right now, and about $20 million of revenue requirements.
Okay. Thank you. That's helpful. And again, in your comments, laying that stuff out is fine. Okay, that's all for now. Thank you. Appreciate it.
Oh, okay. Leslie, I know at one point you were reading from one of your filings. Which filing were you reading from? And you're on mute.
I'm on mute. Sorry. That was our comments in the 19-00296 case, dated July 29th, 2020.
Thank you. Would anyone from EPE like to comment on this? I see Renee Gonzalez, Curtis Hutchinson, and Carrie Olson.
Hi, Judy. This is Carrie again. I think EPE echoes a lot of PNM's concerns and staff's concerns, and we laid these out in our responses to inquiry, but I don't have anything else to add to Leslie's presentation. I have heard Commissioner Fishman's questions and will work with EPE to try to address some of those concerns as well.
Thank you, Carrie. And if you could, list your owned assets versus your, again, I think the vast majority of your renewables are PPAs, but, or at least the upcoming ones. But a list of the ownership and the dollars in rate base, or that would be in rate base, would be appreciated.
Sure, I think, and other representatives from EPE, feel free to chime in, but the EPE ones get complicated as well because obviously Texas isn't sharing in the cost of renewables to meet EPE's New Mexico statutory requirements. And so that is a difference between our system resources and our New Mexico RA procurements.
Right. But you must have an allocation regime that you follow for that, correct?
Yes, I'm sure there is. I'm not prepared at this second on my feet to respond to that. But I know when we're doing the procurement costs for our REA filings, we don't include the renewable system resources. Those are recovered through rate base. We only include the New Mexico REA procurements under our REA cost rider. And so I know we could figure out how that would go into rate base. I just don't know it off the top of my head.
Okay. I'm going to victimize you with a question that I could have asked Leslie, but now that we're on to you, you'll get it. Is that Ms. Padilla had said that PNM sees the purpose of this as tracking the extra cost of complying with the Renewable Energy Act versus if they could have gotten another resource. Which resource do you compare to decide what that extra cost is? You have all kinds of resources that have varying costs. What's your standard for doing that?
I apologize, Commissioner Fishman. I'm having a hard time following the question. Could you say that again?
So I'll do it by an example to make it a little more clear. So I have a renewable resource that's costing me 10 cents a kilowatt hour. And I'm tracking the amount of extra that it cost me to have that resource versus another that's going to go into my rider. Am I making sense so far?
No, I'm sorry.
So some kind of calculation has to be done to decide how much extra your renewables are costing in order for you to put it in the rider. Is that the way it's done, or do you just put the whole cost of the resource in the rider?
Actually, Carrie, are one of the other EPE people, Curtis, might be better situated to answer that question?
Yeah, I'm not sure if, Renee, if you feel comfortable answering that. Certainly not a legal question.
Yeah, it sounds more like, to me, a technical question. I mean, I could try to paraphrase it and correct me if I'm wrong, but it's like when you're talking about excess costs, there's a baseline. And so what is the baseline from which you're determining excess? I think that's the question, right?
Yeah. I don't know if that helps Carrie any, but.
I don't know if it helps anybody, right? Exactly.
I think I'm following the gist of your question. I don't know. That gets a little bit beyond my kind of legal understanding of it. Renee, I don't know if you feel comfortable answering that or if it's something that you'd prefer to just address in the comments that we need to kind of think it through a little bit.
I think we could certainly, Commissioner Fishman, we could certainly address those in the comments, but I'll say broadly speaking, relative to Ms. Padilla's comments, I'm not aware of us making a calculation differentiating between the two prior to my working with the Renewable Energy Act and the RPS filings. I believe that there was a calculation that was required, certainly it went along with the filing, that differentiated between with and without, but I don't know if it's necessarily in the context that you're asking the question.
Yeah. So I'll go back to the answer that Ms. Padilla gave, which, if you're going to have a rider, to me, sounded somewhat sensible with this idea that you compare the entire system cost with the renewable versus what it would have cost if you hadn't been required to get the renewable. But even there, I'm still, it still seems to beg the question, are you treating that renewable as some kind of excess unneeded resource, or has it already fit into your portfolio to meet your capacity needs? And there is no clear way to differentiate it. And do I then compare that, if I call it excess cost, do I call it excess cost compared to my next most expensive resource? Do I call it excess cost compared to my average generation cost? Do I call it excess costs to my least expensive? What's the basis for doing that? And to me, all those things feel like they have the potential to be arbitrary, not necessarily, but they have the potential to be. And it's, worth looking at. And that's part of what confuses me personally when I see the rider. What is it we're really charging for here? And that's, I think, where certainly I need clarity.
Okay, next, Mary Jane Parks. Any comments?
Hi, thank you. No, not at this time. Thank you.
Austin Jensen.
Thank you, Ms. Amer. And I want to briefly touch on what Commissioner Fishman was just discussing. I think the incremental cost piece to, an RPS rider has to assess the excess cost to an alternative resource. And in, our current world of utility resource planning, we're more and more in the case where renewable energy is the least cost resource. So having an RPS rider to recover incremental costs of what amounts to be least cost resource planning seems counterintuitive. And to that extent, I think the revisions here in the rule are appropriate. Turning to the statute that Ms. Padilla referenced, I don't read the statute when saying that a utility can recover through the rate making process as precluding the commission from detailing how a utility should recover those costs. It's a very broad cost recovery statute and it doesn't pigeonhole the commission into any one rate making treatment. And the New Mexico Large Consumer Group has always been supportive of reviewing the commission or reviewing a utilities books and records all at one time. And that's done in a general rate case filing. So the New Mexico Large Consumer Group would certainly support this revision in the rule. Thank you.
And again, Judy, if you don't mind, I'll ask a couple questions.
Oh, no, go right ahead, Commissioner Fishman.
Okay. And so Austin, Mr. Jensen, the way that I see this, sorry, I get kind of informal.
No worries.
The way you framed that, it's kind of taking a position of when we do these riders, it's really a form of piecemeal rate making, and you as a group don't favor that approach. Is that a good summary of your thinking on this?
That's exactly right. And I just realized I had my cover over my camera, so you couldn't see me. But
okay.
That's exactly.
You're a good-looking guy. I'm glad you showed your face.
Appreciate that. The New Mexico Large Consumer Group has always been a fan of treating all the utilities costs and expenses in one proceeding where, when you have single issues like this treated outside of a rate case, there's always the risk of over under recovery. And so you have people on both sides crying, single issue rate making, but rider recovery is, the seminal example of single issue rate making that causes, some serious concerns over, singling out costs and not treating it as, a holistic review process.
Mm-hmm. You pointed out that's often the cheapest resource, but it's a form of cost recovery, but this also goes on a customer's bill. And I don't know, do you have, I own up to my prejudices. I just think it's confusing to a customer. They have no idea what this number means. And, we're going through a process to generate a number that nobody understands. Knowing that that's my prejudice, tell me what your prejudice is.
That's, it's an interesting question to disclose my prejudice.
Well, you don't have to, in those terms. I mean, do you think this is, the question I should really be asking is, do you think this helps when it goes on the bill, helps the consumer understand or evaluate anything?
So I think the difference here, and, listening to staff's comments, I think there is value in showing a customer how much it costs to comply with the state's requirement of, a percentage of RPS resources or renewable resources.
Mm-hmm.
That's an interesting data point to have as a customer. But when the rider, which is designed to recover incremental costs, is not actually doing what it's designed to do, and it's kind of, the slush fund of renewable procurement, and you're procuring some in an IRP and some outside of an IRP, it doesn't accomplish the purpose of showing customers what it costs the utility, what it costs the customer to comply with renewable portfolio standards.
Mm-hmm.
So if the transparency goal was to just demonstrate to customers, the state wants us to do 80% renewable generation. This is what it's costing you. But when you have part outside of a rate case, part inside of a rate case, that's where the confusion lies. And that's why removing the rider and treating it all in one rate case, I think would eliminate the confusion. If the commission wanted to explore a version of the world where you had a general rate case and you could somehow segregate the cost of renewable procurement and put it as a line item, maybe, but you couldn't differentiate between an RPS proceeding in a general rate case where resource procurement is happening in two places.
So might the purpose that staff is talking about, and I understand it as well, be better achieved by not making it a line item in the bill, but perhaps a memo at the bottom of the bill?
Certainly, it can take many forms, but as far as communicating to customers how much it costs for utilities to comply with RPS requirements, we can talk about that more specifically in maybe a follow-up workshop. I think that would be a fruitful discussion. But yeah, I think it can take the form of a memo at the bottom of the bill. It can put an asterisk next to your kilowatt hour charge or your demand charge, whatever it is, and say, part of this charge is the cost of complying with renewable energy portfolio standards. You could maybe say a percentage at the bottom of the bill is tied to renewal. We could talk about that more.
So, and I mentioned that because it seems to me, and tell me if I'm correct or incorrect, that we could probably more accurately calculate that information without trying to make it fit a billing process, and at the same time avoid the administrative complications and the under recovery complications of breaking this out into a separate rider.
I think that's exactly right. And the only way to do that is to do it in a rate case, because you can't get the full cost of compliance with RPS requirements when you have some of the costs being dealt with in an RPS proceeding and some of the costs being dealt with in a general rate case. So I think that's where the confusion lies, because you have costs in two places. And what the RPS rider doesn't accomplish the goal of transparency. It simply just muddies the water as to what costs get lumped into that proceeding. And I think that's where your questions to both EPE and PNM, I think, lie in, like, what resources go into that bucket. It's hard to determine not only the incremental cost of compliance with RPS requirements, but it's also hard to determine what resources are needed and where to put them in terms of an IRP proceeding or an RPS proceeding. So I think, eliminating that confusion and dealing with it in a rate case furthers the goal of transparency and, a utility customer understanding their bill.
And I was pointing out a little earlier that the lion's share of resources that we're talking about here really aren't so much rate case. They're really FPP CAC. They're fuel purchase power clause. So my take on that is that if that's the case, this is not a complicated transition. You just drop the rider and you, at least those costs you put into the lion's share of them, you put into the fuel and purchase power clause. Is there more to it than that? Am I missing something?
To the extent that resources are being acquired or procured through PPAs and not acquired, I think that's exactly right. It's just, moving those costs into a different rider mechanism. Neither should recover carrying costs. So it's just, a simple transfer of expense from one place to another.
And I'll acknowledge that we talked about $20 million in owned assets for PNM. And I don't know what the number is, if any, for EPE or SPS. So,
and SPS has the Hailwind facility, so they certainly do have some.
Yeah, they have $1 billion worth.
Yeah.
$1.6 billion worth, but they're not putting that through the Renewable Energy Act.
Right, and that's their least cost resource planning.
Exactly.
So exactly your point. Like, how do we determine which resources go where?
Exactly. So that's the confusion for me. Okay, thank you for that discussion. I really appreciate it.
You're welcome. Thank you,
Mr. Jensen.
Yeah, thank you, Mr. Jensen. Kelly Gould from NMAREA.
Hi, good afternoon. Thank you for this opportunity to talk about this. And I share a lot of the viewpoints that have already been mentioned. And I also share the concerns that Commissioner Fishman has mentioned in terms of confusion and the arbitrarily choosing what's an RPS cost and what's not. I will just say from my reading of the statute, I'm at 62-16-6. This idea of incremental cost, that the rider is only supposed to be for incremental costs, I don't see that anywhere in the statute. So the way that and I know that the utilities are doing this differently, but the way that I think of the RPS costs are all costs that that go to meeting the terms of the statute, not a difference between this or something else. It's all costs, it's all RPS charges. And I appreciate the conversation that Mr. Fishman was just having with Mr. Jensen. However, my concern with, so I will say that I agree that it is confusing. What's in the rider, what's not in the rider. A lot of it gets covered in the fuel clause. Some of it is in base rates. And I think that that is a really valid conversation to be had and something that the commission can decide how to deal with. However, I will say that there is a nuance from my point of view in the statute that renewable costs for the RPS are treated differently in the statute. So 62-16-6 says that a public utility that procures or generates renewable energy shall recover. So the other resources that the utility they have an opportunity to recover. They don't have a mandate, a shall recover mandate. And so in my thought of having to get rid of the rider, there's this level of complexity of how the utility would ensure that they're recovering their RPS costs. And if we're waiting to rate cases, I think it can get expensive, like staff said, with carrying charges and things like that. I mean, I'm not quite sure how the utility would track these costs. I assume it would be through a regulatory asset or a regulatory liability. And these costs would just, build up over time. It could be quite costly for customers by the time a rate case came. So that's one of my concerns, just the complexity. I think the rider is the easiest way. And I think the commission can definitely say what it wants in the rider and tell the utilities you need to put it all in the rider. But to have it spread over 3 different places, it's confusing. And then it's also to get rid of the rider completely. I'm not quite sure how the utility would track those RPS costs. So that's something that we're concerned about. And I do just want to reiterate, I don't think that the rider is for incremental costs. I don't think that doing an analysis of but for or just the little bit above is what the statute entails. I think it's all resources and costs that are meant to comply with the REA. And when we move to 80% renewable energy, I think that's going to be most of the portfolio. So yeah, so I think that those are most of my comments. I think we'll make more comments on this when we have a chance to do written comments. I do think it's an interesting issue that does need to be addressed. And in our opinion, we think the rider is the cleanest way. We think it saves the most money for customers. And I think that it would be really helpful I think Leslie has offered this and maybe for the other utilities to do kind of a cost benefit analysis so we could really see what the costs are being lost. If the rider's gone, if that's going to cost customers more money, that would be helpful from our perspective. Thank you.
And Judy, excuse me,
Yes,
Madam Chair,
Commissioner Fishman.
Madam Boss.
Yes, Commissioner Fishman.
Ms. Gould, if the rider's meant to capture all costs, would that mean that, I'll take the example of Hale and Sagamore, that they should be included in calculating a renewable energy rider?
Well, I guess I don't want to, I think that this is a really good conversation because I don't exactly know. I think that the rider is helpful for the utilities to be able to keep track of RPS costs. I also agree with you that it does seem somewhat arbitrary what's in and what's out. So I think that there does need to be some closer look at this to come up with a way to manage. For me, in my mind, I think the way that I would think about it is that the rider is a useful rate making tool, and it keeps, the utilities, it allows the utilities to recover these costs that they put through the rider, in a timely fashion without accruing carrying charges. But if it was not put in a rider, there should be probably some other mechanism where the utility tracks its RPS costs from everywhere, from base rates, from the fuel clause. And then I don't know how that looks, like gives a report to the commission. I think that hasn't been done. And I think that's why this conversation is useful. And I think it honestly hasn't been done for a couple reasons. One is because the percentage was so low that it didn't really matter. Almost all the renewal and the costs of renewables were so high. Almost all the renewables the utility were buying were for the RPS. It wasn't a big percentage of their portfolio. And so it wasn't really an issue, right? And now things are starting to shift where the renewable energy costs have come down so much. The utilities are buying those because they're the least cost resource, as the utilities have said and as we've seen. But then they're also using them for RPS compliance. And at the same time, the percentage of what they need to meet is increasing. So we're kind of at this crossroads where it is confusing. And I guess in my mind, I would say that the rider is useful. And like I said, it would be helpful if the utilities wanted to do some kind of cost benefit analysis. But then if the utilities do recover, I think there's also benefit for customers, for the utilities to recover if they choose some of these resources in base rates. And if they choose to do that, some kind of accounting in their RPS case of what it costs to comply with the statute. Like, these are all the resources we use for RPS compliance, and this is what it costs. And yeah, we get some of it here and some of it there and some of it in the fuel clause, but this is kind of the full picture. Mm-hmm. That's the way that I would think about it, and rather than just getting rid of the rider. But then again, if the rider is, I just don't see that the rider costs customers money. I see the other way around. If I'm wrong in that, then yeah, get rid of the rider. But if it saves customers money, I feel like there's benefit to it.
Okay. If I, well, I'm thinking SPS just because we did Hale and Sagamore. So they're going to meet the 40% renewable requirement for 2025 using Hale and Sagamore. They would not be meeting that requirement without Hale and Sagamore. Would that mean that we would, under your discussion, need to include those as part of the rider? Because you wouldn't have met the REA requirement without them.
Well, I think it really is, it depends on how the commission wants to use the rider. I guess my point is that in my mind, there should be some discussion in the RPS and the RPS cases, the yearly cases, of the total costs of meeting the RPS, the renewable portfolio standard. I don't think that's happening. Apart from that, like I said, I think there's benefit to having some in the rider and some in base rates. because I think that the customers having large, plants, like how we used to have coal plants and base rates, can provide benefit to customers. So I think it's really like kind of a case by case analysis. I wouldn't say that it would have to go in the rider, but I would say it could go in the rider. I don't see why it couldn't go in the rider if it's going to meet RPS standards. I think it's the definition of the rider, right? Is the rider meant to include everything? And what is the purpose of the commission? Is it very important for the commission to have everything in one spot? Then yeah, that would have to, in my opinion, that would go in the rider. If it's okay for the commission to have some in the fuel clause, some things in the rider, some things in base rates, and then just have a utility do an accounting in their RPS case of these are the total costs that it takes to comply with the RPS, then, or the rider saves this amount of money, I think that that's okay. I don't know, in my opinion, that the rider needs to include everything. I think the rider is just another tool. And honestly, the rider, I see it going both ways. Like I said, I think we're coming to a head where it's gotten a little bit more complicated because the cost of renewables have decreased. And then also the statute has changed, right? We used to use the rider because there used to be a RCT of 3%, and the rider is really what we use to track that. We also had the other parts of the statute with large customers having like a cap, right? And so there was like these other reasons for the rider, and those other reasons have gone away. So I understand why the commission is looking at this. I do think that the commission needs to think about it though, because I don't know what it's going to look like. Like, is there going to just be a ton of like regulatory liabilities and regulatory assets accruing through the years?
Well, so let me posit something to you, because from a utility standpoint, it seems to me you'd play it two ways. One is the utility is going to get its long-term earnings on its rate base. And the utility almost always, when they have decided to own a renewable asset, will, just as a matter of course, always decide not to put it under the REA and decide to treat it as a rate-based asset for exactly that reason. On the other hand, if it's a PPA, they probably would have more reason to put it into a rider. But what's confusing me, and it's the discussion we had a little earlier, is that, well, you get pretty much immediate rate recovery if you treat it the way or cost recovery, by treating it the way we treat all other PPAs and putting them into the fuel and purchase power clause. So I look at that and I'm sitting there thinking, why do we need this? What purpose is this third mechanism serving us in terms of the rider? So I'm trying to get my brain around that one. And in terms of the statute, you raised an interesting question, I thought. Does the statute, it seems to me, and I might be wrong, so correct me. The statute, it seems to me, seems to require recovery of all the costs. And it seems to me through FPP, through the fuel and purchase clause and the and rate basing, all the costs will be recovered. But I don't believe the statute requires us to track the incremental cost. It just requires that all the costs are recovered. So what's your thought on that?
Yeah, I mean, I would have, and I don't want to speak, I would have to go back and just reread the statute to make sure, but in my memory, there's no discussion of incremental cost. Now with the RCT,
it gets really vague.
But I do think that there is portions of the statute that do require the utility to track all their RPS costs. And specifically what's coming up to my mind is all the voluntary renewable programs. So that has to be tracked. I don't know that it's certain that if it's rate-based, that recovery is certain, right? The utility makes a plan, and depending on how many customers they have, maybe it increases and they make more than they thought, maybe it decreases and they make less than they thought. But I don't, like, I think because we've had the rider for so long, that's my biggest question is how is the utility going to track that? Because I think the utility will track. It says shall recover. So I'm sure the utility is going to be tracking it. If it's in rate base, what are they going to do? Are they going to have a series of regulatory liabilities and assets if they over? And then are they, like, that's the question that I don't know the answer to. If they over collect, is that just earnings because they're allowed to? But if they under collect, then they can come back in a rate case. And I think that they can from the statute. In the rate case, it can say we under collected our RPS costs and the customers owe us this much money.
Yeah.
And that would have carrying costs on it.
Well, my one thought there is that, if it's in the rate base, the recovery is the recovery. They get a, X% return on rate base, and there is no such thing as an over recovery to track.
But
You're
these
just
costs aren't
recovering
the
on your rate
same.
base. Pardon?
I just don't think these costs are the same as rate-based costs. It says a public utility that procures or generates renewable energy shall recover. I think that these costs are different by the statute, and it says shall. And where you buy a coal plant, you have a ROE, and it's maybe you make it, maybe you don't. Hopefully you did your future test year right, and hopefully you did your planning right, but I just don't know that this is the same. I think these costs by the statute are different.
Okay.
And then I think that, I guess I would just say, not that this, I don't know if this specifically matters. I guess for me, for my client, if the rider saves customers money and it's beneficial, we think that it is okay. If the utility buys something that they own and they want to rate base it, I think that that's also okay. I think that now with renewable energy, there's so many PPAs, like we also want the utility to have some skin in the game, right? Because otherwise they're just a pass through, and they want it, like if they have an amount that they own, then they're going to be more, I think, present for customers. They're going to be trying to earn their return on equity, and they're going to be more, I guess, like attentive. If everything is just a pass through and everything's just a PPA, then I think things get skewed the other way, and the utility is just, a pass through. So I don't think that it's wrong to put it in rate base if they want to, and for them to try to earn a return. I just don't know the balance between like the statute and if they, like, I don't know that answer. Like if they put it in rate base, are they just taking the risk? Or are they also going to have a reg asset that they're going to be tracking all their recovery? Like,
Okay.
I just don't know the answer to that.
Okay, thank you. Those are all my questions.
Well, thank you. Someone who joined us is named Kevin Gedko. Who do you represent?
Yeah, I work with the Office of the Attorney General.
Oh, okay.
I joined a little late due to another video conference that I had to be on.
Would you or Gideon Elliott like to comment at this time?
This is Gideon. I'm going to have to leave the meeting shortly, so I think Kevin will get to enjoy the conversation aspect of this. But I will just say that, the Attorney General's office shares some of the concerns expressed by Mr. Jensen and also Commissioner Fishman with respect to making sure that the riders are clear and understandable, and that they, when we have 4 or 5 riders potentially on a customer's bill, it seems that we run the risk of undermining the purpose of the rider as providing a clear tracking mechanism that customers understand. So that is our one of our concerns. I think another issue and term of art that I've heard recently is leakage, counting leakage. Insofar as it's difficult to tell the difference between some of these costs that are supposed to be recovered in the rider and those that might already be in base rates. And I think that Ms. Gould really spoke to the difficulty of figuring out a solution to that. So those are the extent of my comments, and thank you.
So I'll again just ask a couple questions. It sounds like in that second point, you're a little bit concerned that you called it leakage, but it could also be called double counting or perhaps undercounting. It could be an error either way. Is that specifically what you're speaking to, Mr. Elliott?
Yes, Commissioner.
Okay, just wanted clarity on that.
Yeah.
You get off easy. That's my only question.
Thank you. Grateful. I'm sorry I have to run. This has been really informative, and thank you.
Could I just add one thing at this point? This
Yes,
is Leslie.
certainly.
Because one thing I think we need to keep in mind, especially this, Ms. Gould's comments reminded me of this. I mean, we're obligated every year, the utilities, to make Renewable Portfolio Act filings. And so that's still an annual requirement per the statute. And every year we have to show how we are going to comply with the RPS mandates. There is going to be another significant bump up in 2030, I believe. I hope I'm getting this right. And then the following significant bump is, let me look at so while we're kind of in this period that I think Ms. Gould described pretty well, now we've got, say 2025, we're at 40%, then 2030 renewables are 50%. So every year the utilities have to make sure we are going to hit those requirements. So we may see at the 2025 and 2030 points that utilities do. I'm not speaking to PNM specific circumstances, but we may see in the next 10, 15 years where utilities do have to acquire additional renewable resources to meet the RPS, taking us kind of back to where we were when we first started down this road with the RPS requirements. And each year, the commission is approving those plans, and any cost that we are seeking to recover through the rider, there's a commission approval of those costs. So I just wanted to make that clear in terms of everything should be transparent because of the annual nature of our filings and the requirement that we get those resources and cost recovery approved. That's all. I just wanted to add that. Thank you.
Point taken, and it's a good point.
This is Kevin, just kind of continuing.
Yes, Kevin, go ahead.
I missed the first part of it, but just kind of in response to what I've just heard a little bit is I do see this question of, as the percentages get greater, kind of in direct contrast to what Ms. Padilla just said, it feels like to me this process of acquiring renewables becomes more of the standard as opposed to the exception. And so when we talk about what something represents, to have this rider that was supposed to represent the exception, and all of a sudden we're going to be in a world where it represents the norm, I think we have to really question the whole basis for continuing down that road. And I'm new to all this, and I could see that there being a need to change it statutorily, but that doesn't mean we shouldn't try to adjust given the statutes that we have so that we have a clear understanding of what we're doing, as opposed to using something to do the opposite of what it was intended to do. And that last statement's a little bit too strong, but I think you guys understood my point. And then the second piece is, I pulled up 62.16.6 that was referred to by Ms. Gould. And the one word where I kept reading it, it says, a public utility that procures or generates renewable energy shall recover. And that's what we focused on. Then it says through the rate making process. And then it says the reasonable cost of complying with the renewable portfolio standard. So at first I was really concerned. I was like, well, if they shall recover, and then we're going to be at a point where it's 80%. Well, where does my power go as a consumer advocate to like defend whether good decisions are being made? And then I said, okay, but it says reasonable there. Okay, well, doesn't that take me back to where I am when I'm normally discussing prudence and trying to understand what's happening? But perhaps I'm missing something, and I just wanted to interject that into the discussion and maybe get an understanding of, is it really a shall if we're only talking about what's reasonable?
So let me ask you a question, Mr. Gedko, and I want to call you Kevin, but I'm going to call you Mr. Gedko. Is if we took the statute super literally and we included every renewable cost in the rider, pretty soon the rider would be 50-60% of your bill. Is that what you were speaking to when you were saying we seem to have taken something that's supposed to capture an exceptional cost, and now it's turning into something that's just normal cost of doing business?
Yeah, that's a logical conclusion of where I was going. It's perhaps said a little bit more clearly and shows the effect of what would happen. Correct. Yes.
Okay.
Ms. Amer,
go ahead.
sorry,
Yes.
Leslie Padilla again. This kind of relates to the point I just made about annual RPS plan filings. When PNM is seeking to add renewables as part of our system resources, we're not making those proposals as part of our annual RPS filings. In general, it might not be every circumstance, but certainly San Juan replacement resources, Palo Verde replacement resources, we're making those in independent filings. So the statutory provision that Mr. Gedko just looked at, those costs would not be, because the next sentence of that section says that costs that are consistent with commission approval of procurement plans shall be deemed to be reasonable. So it's those annual RPS filings when we're having to add additional renewables to meet the annual, RPS requirements. When we've made those in the past through our Renewable Energy Act filings, those are deemed reasonable if the commission approves those plans. But those won't be the renewables that we're adding again to meet system resources because they're the least cost resources right now, or for other reasons that we related to the ETA, for example. Although that gets complicated because obviously the ETA is related to the renewable energy.
I have a question, Leslie, but aren't there some sources that are partially for the system and partially for RPS compliance? I mean, it sounds like you have it very cut and dry. This is for the system, this is for RPS compliance. I would think some utilities might have some resources that are system, but also for RPS compliance. either all or in part?
Yeah, I don't know, and I don't know if there are examples in past RPS cases where we've sought approval for new resources. Maybe Mr. Buffington can help me out if he remembers where we've sought approval for renewable resources as part of our RPS plan, but we considered them more a system resource. I'm not sure if that's the case or not.
Well, we have sought resources in our RPS plans.
Sure.
We recently did it in, I think, 2017, but really the way we look at it is, even those renewable resources that we have for system needs, we do also retire RECs from those systems for RPS purposes. But the purpose of the facility itself was not to meet the RPS standard, it was to meet a system need, but we just also happen to use it for RPS compliance.
And following up on Judy's question, I'll take the example of San Juan replacement resources. The original preferred proposal included 6 or 7, I can't remember the exact number, of Aerojet peaker type generators, which eventually in the approved proposal, all were eliminated in favor of renewable resources. And in the course of that decision, the immediate cost wasn't the only driver. And of course, we talk cost, there's the immediate cost and there's a long-term cost, which in many cases is a little bit unknowable and subject to debate, depending on how you develop the rest of the system around it. But there's a case where they become system resources, yet clearly there was in the decision, a decision to say that a little bit of additional cost was perfectly acceptable given all the other needs we were trying to meet. Yet none of that is, as I understand it, is captured in the rider. So again, I'm looking at something that feels like we're trying to measure something that maybe is not practical to try to measure. So anyway, any responses you guys have to that, I'd be interested in hearing.
I think at this point we should go on to section 22, where the big change is. I mean, there's smaller shalls, and if anybody has any comments about those smaller wordsmithing type changes, please speak up. But if everybody's amenable, if we go to section 22, financial incentive, as I detailed earlier, this was the subject of many inquiries and responses filed by many utilities. And, we have looked at all of them and discussed them. And after all that consideration, this is the thinking at this point. As I stated before, we have not issued a NOPR, so it's open for discussion. That being said, I think the change in A just makes it more clear. It doesn't really do any substantive change. The change in B generally tracks the language of the statute, which I can't remember. I believe it was David Black who stated that 6216.4 states that a financial incentive or a financial or other incentive shall be related to the public utility producing or acquiring renewable energy. After, and instead of the effective date of this rule, the effective date was May 4th. We got rid of the word measures because it didn't seem to add anything, and it appeared to create a confusion as to what was a measure. And the statute is clear enough without it, which is it has to be producing or acquiring renewable energy. Robert, can you go to C and D? We have two wordsmithing, and then lastly added F to make it clear that, hopefully clear, a financial incentive shall only be used to incentivize, again, the production or acquisition of renewable energy to accomplish the requirements of the rule A1 through 3, which tracks the language of the statute. And it shall not be utilized to incentivize only a closure of a carbon dioxide emitting resource. And with that, I might run through the list again. If everybody's okay with that.
Judy, this is Robert.
Yes.
I do have a quick comment that I just want to point out for everyone. Up here in paragraph A, so originally this did track the statutory language very closely, but we did make this change from a plural public utilities to singular because I think it just makes more sense this way. In the statute, it goes from a singular, or reads the public utility must file these financial incentive to encourage public utilities, plural. And I believe that's pretty ambiguous how the statute's written. So I just want to point out that we changed this to try to be more clear. And if anyone has any input on that, I'd like to hear it. So.
Yeah, that's a good pointing out, Robert, because you're right. It does go from singular to plural in the statute. And so that's a good change in my opinion. But anyway, could staff weigh in at this point, either Alicia or David Black?
Yes, this is Alicia Leyba-Tercero. And so with regard to the revisions to the language under subsection B of this section, as well as the new proposed language under the new subsection F, staff supports these modifications because staff believes that they are consistent with the statute, specifically 62-16-4D, with regard to the financial or other incentive must be related to the public utility producing or acquiring renewable energy. Thank you.
Okay, P&M. Leslie.
This is Leslie Padilla. On the incentive section, I'd first note that P&M has moved to intervene in SPS's appeal to the Supreme Court of the latest rule amendments. And our interest in that appeal includes the incentive provisions because we believe that the language, the new incentive language that's now in the rule doesn't make it possible to reasonably obtain an incentive as allowed by statute. And the new proposed changes to 22B kind of exacerbate our concern because it appears to preclude a utility from retiring excess RECs as a basis or even a partial basis for receiving an incentive, So we'll be looking at this a little further internally and submitting written comments at the end of the month. So thank you very much.
Thank you. EPE, either Renee, Curtis, or Carrie.
This is Carrie again. I echo some of the concerns Leslie brought about the connection to the pending appeal and the added complications this may make. I also wanted to point out, this isn't substantive, but it looks like in the header as well as in subsection F, the rule number is transposed. And I don't know if that.
Oh, I see. It's 572, not 527. Thank you.
And it looks like it, I think it may be in the existing rule too, but the bolded header
you're
does
saying?
the same thing.
Oh, no. Yeah, you're right. This will change it.
And it looks like the same as in the reserve section. I don't know, it doesn't matter because it's reserved, but odd.
Well, thank you for catching that. And then next, Mary Jane Parks. I don't know if she's here anymore. Austin Jensen.
Thank you, Ms. Amer. I'd share staff's comments here. The changes to remove measure and include producer require tracks the statute, and the addition of the date here also, clarifies. We just litigated SPS's case, RPS case, and this was a central issue in the case where SPS was trying to seek incentives for past conduct. And, the basic definition of an incentive is to incentivize future conduct. So simply getting an incentive for what the utility, is already doing based on, least cost resource planning shouldn't come to the detriment of ratepayers. So we certainly support this addition of the date requirement and also support section F as well. Thank you.
Thank you. Kelly Gould.
Thank you. I'm gonna have to look at it more and save my comments for our written comments. I do know that it's up on appeal at the Supreme Court, and I'm just not sure, the complexities that creates, but we will comment on it. Thank you.
Thank you. The Attorney General, Kevin Getko, I believe, is here, and Gideon Elliott is no longer here.
Yeah, I only have one minor comment on it. Under F, it's not on, sorry, I'm looking at my screen, but on your screen, if we can bring up the F. I just noticed that it shall not be utilized to incentivize only a closure. I mean, it all feels pretty clear to me, but the trouble that we've had with closure versus abandonment and what that's led to, I wonder if it doesn't get added to tighten things up just even a little bit more. That's just one thought.
Are you saying abandonment or closure? Are you proposing abandonment or closure?
Yeah, and I don't even know if I'm proposing. I'm just
okay.
recognizing that I have been learning and seen difficulties with that in other cases, and feel like maybe goals of statutes haven't been achieved due to the manipulation of closure versus abandonment. And I don't ever want to face that again. And so if it was appropriate, I think there's other minds on here that are smarter as to whether that's needed or not, but I want to express my concern.
All right. Well, I think what we'll do is talk about it and think about it. Unless someone
Judy,
else has a comment
question,
about
a
that.
question.
Commissioner Fishman?
Yeah, I'm
Go
sorry.
ahead.
I was talking
ahead.
over you there. Following up on this idea of abandonment versus closure, I keep forgetting, it seems to me that abandonment is a requirement under the REA, but not under the ETA. Am I correct in that or not?
I would have to research that.
Or I should say I got that backwards. Closure is a requirement under the REA, but not under the ETA.
Well, I don't personally know the exact answer to that. I would have to research it.
So yeah, we should get some clarity around that because I think Kevin raises a really good point.
Yeah, I think it's a great point that I don't know the answer to. So we should look into that.
Judy, this is Kelly Gould. If you have it offhand, the the statutory provision that this F is related to, I heard a comment that said it tracked the statute, and I was just looking for that language.
Oh, this does not, this one, I don't think tracks the statute per se. It doesn't conflict with the statute. The statute is 62-16-4C or D, sorry, D, and it says for production or acquisition. And it does not use the word abandonment or closure. And I believe that's the statutory provision.
Sixty-four, 62-16-4 D is in dog.
D, yes, yeah. Let me make sure that.
Thank you.
Yeah, it starts upon a motion or application by a public utility, the commission shall, or upon motion or application by any other person, the commission may open a docket to develop and provide financial or other incentives to encourage public utilities to produce or acquire renewable energy that, and then there's the three things. So to produce or acquire would be the statutory authority. Well, unless someone else has some other overarching topic, I propose that the workshop conclude, but I definitely am open to anybody asking to say something at this point. Well,
I'll just say thank you to everybody, Judy. Appreciate a good discussion.
yeah, I echo that. I'm pleased with the attendance and with the participation. Thank you. And with that, we will conclude. And we'll see you soon.
Thank you.
Thanks, everybody. Thank you, Commissioner Fishman. Thank you, Judy.
Bye.
Thank you.
Thank you, everyone.
Thank you. Good night.